Good afternoon, and welcome to Marshall, Parker, and Weber's webinar. Today, our topic is gifts, tied with ribbons or with strings. I'm sure you're sitting on the edge of your seats to hear what this is about. I am Managing Attorney Tammy Weber, and I'm here today with Patty Turner.
Hi there.
Patty's been with the firm for, I think, what, 21 years?
Yeah.
All right. So today we're going to talk about different types of gifts and how the consequences are viewed by various agencies, like the Department of Revenue, the Internal Revenue Service, and the Department of Human Services. So what is a gift? We all like to see things with nice, big bows. But there are different types of gifts. So Patty, what's your favorite typical gift?
My favorite typical gift is jewelry.
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 So it doesn't matter whether it's for birthday, Christmas, or...
It does not matter, but either one of those would be appropriate. And I'm not opposed to Valentine's as well.
Okay. So those are the first kinds of gifts that most people think of. Anniversary, Christmas, Hanukkah, 'tis the season. But there are also charitable gifts. So sometimes you might have a church or a cause that you believe in, and they've received status from Pennsylvania that if you give them money, you can receive a charitable deduction on your tax return. Some people do those for estate planning purposes. There's also the gifts to avoid paying Pennsylvania inheritance tax. I have to say, Patty, when people come in, we always on their confidential client questionnaire ask them what their goals are. And what would you say, at least half of the time?
Probably even more than that, but nobody wants to get caught paying those taxes.
So that would be one of the gifts. And then there are also gifts as part of a long-term care plan, either planning ahead and transferring things to irrevocable trusts, or transferring them from one spouse to another. So let's take this a little deeper and talk about how the gifts can be made. Check or cash? You'll take that after the jewelry, right, Patty?
Either one will be fine, thank you.
Okay. Sometimes it's transfer of ownership. Can you think of an example, Patty Jo?
Well, I think it classically is if you're talking about house. If someone transfers their house to you, typically mom and dad to one of the kids, that's a transfer of ownership, but that's a big gift.
So usually when the clients say, but I paid $1 for it, that's still a gift, right?
It's still a gift.
Sometimes a gift is adding a name to a deed. Maybe you don't give them the entire house, you just add them on. Or adding it to a checking account, a savings account, or things like that. And sometimes paying expenses for others. We've seen this often. What would be some times you think that people pay expenses for others that would be gifts, Patty?
It's pretty common for someone to pay college tuition for someone else. They often are paying medical bills for someone else who is having trouble meeting those needs, or sometimes even living expenses for someone who's close to them.
And sometimes we see the family vacays, right?
For everybody.
Yes, they all go, all 15 of them.
Everybody gets a ticket.
We never hear how it goes, but they all like to go off to Disney World or Tahiti or something together. So more specifically, the gifts can be made. So if you don't want to pay the institution of higher learning directly for your child or your grandchild's education, you can set up a college account. Sometimes these are TAP accounts or 529 accounts would be one way. Another is a charitable gift annuity, and again, these are the high points of different kinds of gifts that can be made, and the reason for the gifts varies between different individuals. So these may not be the best gifts for you or your clients if you're listening, and we just want to provide you with some points to think about. So a charitable gift annuity might be as you age and you're retired and you have really too much money, but you don't want to pay as much income tax. So you give a portion of that to the charitable institution. They have the use of some of the money, and you receive an annuity payment during your lifetime. And so there's income coming to you, a positive for the charitable unit, and also a positive income tax consequence for you as the individual. Somewhat aligned with that is a transfer of appreciated stock. Sometimes there's a better benefit if you bought a share of stock for $10 and you've done a good job and it's worth $210,000. That's really good.
That is good.
It could be. You have lots of shares. It's worth $210. You've made $200 per share on that stock. If you were to cash it in to write the check to the charitable organization, then there will be a capital gains analysis that would have to be done. But if you transfer the stock itself to the charitable institution, the income tax consequences are much more positive for you. Patty, have you had a situation where people disclaim an interest in a property?
There are times where someone stands to inherit something that, frankly, they don't want. So they exercise their right to disclaim or waive away any interest they have so that they don't have to take ownership of that 15 acres that needs mowed out in the North 40. It may be something they're just not interested in. So that might be an example of when someone would rather not receive an inheritance.
And so the act of saying, no, I don't want it, is really a gift back to the estate for the value of whatever that item is.
It is, because otherwise it would have been yours.
Exactly.
You've given it back.
So if the North 40 were worth $100,000, you were making a $100,000 gift.
That's how it works.
All right. Another one that people don't typically hear about, and this really is from the state's perspective for the Department of Human Services, is an unsecured loan. So often we see people come in and one or both of the spouses needs to go to a nursing facility, and we're talking about have they made any gifts? And the parent goes, no gifts. We get to talking a little bit more and we find out, well, I loaned my son $40,000 2 years ago. Well, is there anything in writing? No. Is it secured? No. Is your son going to pay it back? Well, he says he's going to. So the way that would be treated with the Department of Human Services is a gift. It's not an arm's length negotiation. So these are just some of the types of gifts. What are the consequences? So the Department of Revenue is the organization in Pennsylvania that typically reviews inheritance tax returns. And we've done other webinars on estate administration and inheritance tax that you will be happy to go to and pull up on our website, which is paelderlaw.com. But often when people come in and they want to avoid inheritance tax, they say, how do I do it? So first it has to be a completed gift. In other words, this will go well at your house, Patty. Say one day you decided you didn't want any belongings in your house, and you tell your children they're yours.
They're all theirs, yes.
In order to avoid Pennsylvania inheritance tax, you have to give them to the kids. You can't keep them in the house.
So if I want to give them the couch, I have to actually give them the couch.
Yes.
Oh,
You have to give up possession.
well, then I'll rethink that.
Okay. And then you need to survive a year and a day from that gift. This always wasn't the case, but in a few years back, the Department of Revenue and the state got wise that people with an unfortunate bad health diagnosis were just giving all their assets away before they died so that their heirs didn't have to pay Pennsylvania inheritance tax. And just as a little highlight, inheritance tax rates are 0% for spouses, 4.5% for lineal heirs, meaning children and grandchildren, and 12% for siblings, and 15% for everybody else, nieces, nephews, neighbors, etc. If the only exception to that in Pennsylvania is life insurance, and that is 0% for whomever is the beneficiary. So, Patty, if you have an extra $100,000 laying around, I say congratulations. And then if you were to write a check to your daughter for $100,000 and live a year and a day, she would essentially save 4.5% or $4,500 in tax.
Right.
The next one is the one that I see the clients get concerned, confused, and somewhat not happy about. If they come in and their parent has done, at some point in their life, what's called a life estate deed. And so what this means is I own a house, and I want to make sure that when I die, it doesn't go through my probate estate. So I may choose to put my beneficiary on as a remainder owner. Right now, that is a protection for medical assistance purposes, but when I die, the remainder owner owns my entire home, and it has to be appraised for a date of death value. And the good news is there's a step up in basis. So if I bought my house for $50,000 and I die and it's worth $250,000, that's the rate at which my heirs inherit it. They won't have to pay capital gains tax, but it is subject to the 4.5% if my heirs are children or grandchildren, Pennsylvania inheritance tax. We see lots of times where clients maybe went to a general practitioner and were not explained that inheritance tax will be due at the time of the death. What, from the Department of Human Services standpoint, different consequences of a gift. So some of the work that we do here is to help people qualify for medical assistance or Medicaid. And there are two requirements to get on medical assistance or Medicaid. You have to be physically need long-term care services. In other words, you need help with at least 3 activities of daily living sufficient to be in a nursing home. The financial requirement is the second requirement. After those 2 requirements are met, when you apply 5 years prior to the date of application, they look back, meaning the state, the county assistance office, for 5 years. When you apply, you have to disclose all of the gifts. The question, though, is what are the consequences of any gifts that happened in those 5 years? Under the current rule, and I stress current, so we're sitting here today in December of 2018, the rules we're discussing are those in effect now. Gifts with a cumulative value of greater than $500 in a calendar month create a period of ineligibility. So, Patty, you have 3 children. Can you give them all $500?
Not if I want to avoid this creating a penalty. I can give $500 to my son this month, $500 to my daughter next month, and $500 to child number 3 the 3rd month. But it's a total of $500, not $500 each.
And those are normal kind of gifts, or the typical gifts we talked about. Also, the Department of Human Services views as gifts things to charities, or tithing to your church is the general rule. The other thing I think of note is, say you forgot to do those checks, and it's December, Can you play catch up and write 12 times 5 is 6,000 today? Are you going to create a period of ineligibility?
You sure are. Unfortunately, those gifts have to be made per month, and then the calendar starts fresh every month, so you don't get a chance to go back and go, oh, I missed April, May, and June, so I'm going to do 1,500. That's not okay. You have to stay with the $500 max per month, no catch-up.
Okay, so let's talk about then, when are you ineligible and how does that work? So if you've made gifts, there's a Medicaid penalty divisor, and this is where we get into math. So typically once, sometimes twice a year, the county assistance office, the state, calculates what is the average cost of nursing home care in the state of Pennsylvania per day. Right now, that cost is $330.19. So for every $330.19 that the applicant for Medicaid gives away, they're ineligible for 1 day of Medicaid paying for their care. And that works out to be a little over $125,000 per year. The tricky part, though, is when does this penalty start? It used to be before the Deficit Reduction Act was passed and incorporated in Pennsylvania, it would start at the time the gift was made, in the month it was made. Now, in Pennsylvania, that penalty starts when the applicant is otherwise eligible for Medicaid. So what otherwise eligible means is they've met the physical requirement, meaning they need help with their activities of daily living sufficient to be in a nursing home, and the financial requirement, meaning their available resources are at the resource limit. So for ease of explanation, say it's a single individual that is applying for Medicaid. The most that individual can have from a resource amount is $8,000. So if they need to be in the nursing home and they only have $8,000, and that's when the penalty starts, it can be a little tricky. Where are they going to get the money to pay through the period of time they're ineligible? That's what we do here. We're just explaining to you what the consequences are in terms of thinking ahead. And at the end, we'll talk about some of these additional things that you might want to think about. So the other thing we often hear about, Patty, how many times have we heard, but can I give away?
Wait a minute. I can give away $15,000 a year, right? No, not for medical assistance purposes. There's a whole different set of rules regarding gifts that are looked at by the Internal Revenue Service as opposed to the Department of Human Services. So it seems unfair that one gift can have multiple sets of rules applied to it, but that is, in fact, what's happening. So when most people are thinking of this $15,000 a year, that's not going to apply. It's a rule that falls under the federal estate tax provisions, and to be in a category where those apply to you, you have to be substantially more wealthy than most individuals. Tammy?
No, if you're thinking I am, you're wrong. So right now, the lifetime exclusion from federal estate tax is $11.2 million per person. So the IRS says you don't have to pay when somebody dies or a flat rate of 40% for anything under that amount. And in addition to that lifetime exclusion amount, you can give away $15,000 per person per year without it counting. And this is something, congratulations if you're in this category, that You should be talking to your accountant and or your certified elder law attorney, because it's sometimes very prudent to file an IRS Form 709, which shows that gift. And basically the IRS, from the time that that's filed, has 3 years that they can agree or disagree with the value that you put on that form. So what we hear next are, well, gee, we're back to the people like most of us who are thinking about Medicaid. Are there any exceptions to this Medicaid penalty for disposing of an asset for less than fair market value? So the good news is, yes, there are some exceptions. Now, we don't count on them always being here. We put a couple here on the slide. So if you transfer your residence to your spouse, again, you would have to disclose it on the Medicaid application, but there would not be a period of ineligibility for that transfer. You could also transfer your resident property to your child under 21 years of age without a resulting penalty. Or, this is called the disabled child exception, a child age 21 or older who is blind or permanently and totally disabled. Another exception that we often see is what we call the child's caregiver exception. So this is if a child moves in with the parent to care for them so that they don't have to go to the nursing facility, and that child has lived and provided care to the parent for at least 2 years prior to institutionalization. So there would have to be a doctor letter that says, but for Patty living with her mother and caring for her, her mother would have had to have been in a nursing facility. So again, that has to be 2 years. And Patty can't have her own house. She's really given up her house. She's given up her mode of operation to care for her mom.
So the reason you're getting the exception here is because you've given up something to help care for mom. So the state is kind of rewarding you for that.
Right. So the state really didn't have to pay also for 2 years of care under Medicaid potentially. There are some additional exceptions. And again, it's case and fact specific. So when in doubt, have a consultation and we'll talk about your circumstances. So I said that we'd talk about what are the consequences of the gift. This could be a whole long list, and when family standpoint and dynamics get involved, this could be the breaking point for some of our clients. But if you give it away, you can't get it back. So if you're, years ago, I did many deeds, talked to a client, and they wanted to do outright deeds to their child. And I ask all the questions. Child, and they're sometimes uncomfortable, but that's the way you're going to get the best legal advice for yourself or for your clients. And I said, any substance abuse problems, any gambling problems, drinking, etc., opioids, anything going on, that if you make this transfer without any strings to your child, that 5 years down the road you might say, that wasn't a good idea. And they all told me, no, no, no. Now, I realize you can't anticipate what will happen in your family. But what happened was 4 years later, we got the call, and we're told that one of the people to whom land was transferred had an addiction issue, and they had done an intervention, and the family wanted me to be able to get the land back. Well, you can't, not unless that child agrees, and the spouse was also involved, so it wasn't going to happen. You can't get it back. The other big, big issue is if you give things away, or in a real negative case, one of your children takes things from you by having a little spree with your checkbook or things, and the money's not available, there is a concept that's been in Pennsylvania law history for hundreds of years called filial responsibility. We are going to have a webinar by my partner Matthew Parker on February 13th, I believe, to go into this in more detail. But in summary, if your parent is in a nursing facility or even in a personal care home, the spouse or children can be liable for the care costs of the parent, whether they're the good child or a bad child. It doesn't matter. And we've seen many suits from nursing facilities because once your parents or the parent is there, if they have no money to pay or there was a period of ineligibility that cannot be paid through, then the nursing home can sue the child because they cannot discharge the parent without a safe discharge plan. So it can be a very nasty consequence and not the legacy that our clients want to leave for their children. So we have about 1 minute or so left. If anyone has any questions, there's a little box to the right. We'd be happy to answer those questions. I'll remind everybody that we do upload these webinars and put them on our website, paelderlaw.com. And again, all of the information you received today is general and based upon today's rules. We're not getting any questions. So I hope that means Patty Jo and I did a good job. Thank you very much. We look forward to seeing some of you in the future.